security issues in the country remains a source of worry for many, but on our interview segment, Mr. Fola WORREY expresses the opinion that the Nigerian police force lacks character, also showing the views of participants and speakers on dispute resolution and the commercial realities at a legal seminar which held recently in Lagos. It's great to have you join us on another episode of Law Weekly on Channels Television. I am Shola Adeko. Let's commence today's proceedings with a recap of some of the top stories in the news last week. 13 years after his death and 2 weeks after the 18th anniversary of the annulled June 12, 1993 presidential elections, late Chief Moshood Abiola was back in the news. It's the matter of his will, and the Lagos High Court, sitting in Ikeja, made an order that the administrators of his will should be allowed access to all his assets, both home and abroad. In an enrollment order granted by Justice Olubunmi Oyewole, the court also directed that everybody who has information regarding any and every assets belonging to the late Chief MKO Abiola is hereby compelled to release all such information relating to such assets to the administrators of the estate. The court also ordered the resealing of the grants and giving effect to the orders of the High Court of Justice of England and Wales, the District Probate Registry at Winchester dated 6th day of October 2004, and the High Court of Justice, Chancery Division in London, dated 22nd July 2010, giving validity to the will of the deceased dated 25th October 1980, and appoint the persons named therein as administrators until such time as the said administrators are able to conclude the task of identifying and gathering all assets of the deceased. This order is expected to give effect to the last testament of the late businessman, where he willed money in his accounts in UK to some of his immediate and extended family members. Aside the matter of the will, the second son of the late politician was also in the news, but for the wrong reason. Another judge of the Lagos State High Court, Justice Adeniyi Onigbanjo, ordered his remand in the custody of the Economic and Financial Crimes Commission, EFCC, after he was accused of stealing and fraudulently converting the sum of 35.5 million naira. According to the anti-graft agency, the late politician's son had collected the money sometime in 2008 from one Jide Jose under the pretext of importing printing machines from Switzerland for him, machines which were never supplied as the money was allegedly diverted for personal use. Mr. Deji Abiola is expected to be arraigned on the 30th of June before Justice Onigbanjo. It, however, remains to be seen if Justice Onigbanjo will continue hearing another case, the one involving the former managing director of Bank PHB, Mr. Francis Atuche. Last week, the EFCC asked him to disqualify himself from the case. The Commission filed an application to that effect after the Chief Judge of Lagos State, Justice Inumidu Akode, refused to reassign the case from his court, as requested earlier by the anti-graft agency. The former bank chief was charged with two former directors of the bank, Mr. Lekan Kasali and Mr. Fumi Ademosun, before Justice Onigbanjo, on a 3-count charge of conspiracy and stealing of over 11.4 billion naira belonging to the bank. But the agency is alleging that he has lost confidence in the ability of Justice Onigbanjo to hold the scale of justice in the pending charge, on the basis that some of his comments in the ruling on Mr. Atuche's bail application might have inadvertently prejudged the substantive charge and pending applications. The court is adjourned till the 19th of September to enable the defense respond to the EFCC's application. Justice Latifa Okunu of the same court has, however, granted Mr. Atuche bail in a similar suit pending before her. After 5 weeks in detention, the former bank boss got bail in the sum of 50 million naira with 2 sureties in like sum. His application to quash the charges against him was, however, dismissed by the court for lack of merit. The former Speaker of the House of Representatives, Honorable Dimeji Bankole, however, has to wait a while to know if his application asking the court to quash the charges against him would succeed. Honorable Bankole contends that the Abuja High Court lacks the jurisdiction to try him for anything done by him while exercising his powers as the Speaker of the House of Representatives. Citing the provisions of the Legislative House's Powers and Privileges Act and the National Assembly Service Commission Act, the former Speaker says he only acted in his official capacity. In an application to quash the charges of illegally obtaining 37.7 billion naira loan leveled against him by the EFCC, Honorable Bankole says there's no shred of evidence to sustain the 17-count charges against him. He has therefore asked for an order to be made directing the chairman of the EFCC to publicly apologize to him for the public humiliation, denial of personal liberty, unlawful detention, and discomfort to his person and family since Sunday, the 5th of June, when he was arrested. Now, during the week, ESQ legal practice seminars assembled a stellar panel comprising international experts, key regulators, in-house counsel, and private legal practitioners to debate and explore current commercial realities and how to bring dispute resolution in tandem with them. I attended that seminar and thought it wise to share with you some of the discussions from there. Anyone and everyone who has a business or who is thinking of starting one can benefit from this.
ESQ Summit is set as a forum for debates between international practitioners and the industry on trends and developments in international commercial arbitration. Our focus basically is to look at some of the perennial issues that are arising out of dispute resolution in Nigeria and the implications for development of commerce in Nigeria.
That's the key focus of this seminar organized by ESQ Legal Practice Seminars, which had in attendance senior lawyers like Mrs. Folake Sholanke, the first female senior advocate of Nigeria, Mr. Abdullahi Ibrahim, former Minister of Justice, Mr. Bayo Joe, another former Attorney General. Also in attendance were lawyers from the UK, lawyers in politics, in-house company lawyers, and of course those in practice. They've all come to contribute to the topic of dispute resolution in business and commercial activities. There was a debate as to whether it was better to solve such disputes through litigation or arbitration.
Businesses do not have to tie their hands right at the start of the dispute. They can, as it were, seek to have their cake and or eat their cake and have it. And they do this by incorporating into their agreements what are known as option clauses.
At the centre of the wheel of conflict are needs. It is my firm belief that if we deal with needs and we identify needs in all our conflicts and all our disputes, that we will resolve our disputes in a much quicker and much better way.
The point was made that a properly drafted multi-layered dispute resolution clause should have the flexible mutual option clause of arbitration or litigation for both parties. The issue of exclusive jurisdiction of courts was also explored and identified as one of the major causes why the wheels of justice in the courtrooms grind so slowly.
I think we should slow down exclusive jurisdiction. If we can't do anything at all, we should let there be no more exclusive jurisdiction courts. I hear people clamoring, EFCC wants their court, SEC wants a court, the commercial people, they want a court. There are some other people who say they want court. ICPC, yes, ICPC said, yes, they said they want their own court. Then we will then have exclusive jurisdiction in EFCC court. We will spend 13 years arguing whether this is supposed to be in the federal government.
One of the major innovations, as I said, in the 2004 rules, which we have tried to build on and strengthen in the review that we did, is this business of front-loading. Now, the evidence that is required for a case is required to be produced. At least the nature of the evidence is supposed to have been produced at the beginning of the matter. If all the parties know what evidence that they are going to meet in court, it may actually also help a swifter resolution of the matter, because when you realize that you are operating from a position of weakness at that early stage, it would probably help you even in determining and advising your clients that the likelihood of success in this matter is slim. Look at the evidence that is stacked up against us. What do we have to respond to it? But unfortunately, I don't see that as having happened over the last few years of the operation of these rules. Everybody still wants to have their day in court, even when you know that the likelihood of succeeding is quite slim.
The seat of arbitration, especially the emergence of Lagos as an international commercial arbitration center, also came under the spotlight.
In many cases, especially when I see arbitration agreements coming out of Africa, often parts of Nigeria, there is usually a provision that this arbitration should be conducted in accordance with the arbitration and conciliation rules of Nigeria, but with a London seat. I think that in those contexts, it appears that the parties treat seat as simply location, but the seat is slightly more important than location. And to put this point in context, one could ask, assuming you choose to litigate in England, is it possible to say this dispute shall be resolved in England in accordance with the civil procedure rules of Lagos State? It's simply not possible.
The Lagos Arbitration Law is a better version of the Arbitration and Conciliation Act. Why has the Lagos State government done this? If you look at Section 1 of the Lagos State Arbitration Law, it starts by stating the principles which govern that law. It says that one of the principles is to enable parties to obtain a fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. So we've looked at the issues of there's delay, there's expense. Can you get an impartial tribunal? These are the things that international investors want.
At the end of the day, the robust discussions at this conference will no doubt challenge lawyers and businessmen to better manage disputes and significantly save time, money, and relationships.
It's 30 minutes of creativity, exhibitions, the usual, and the bizarre. Not forgetting all those mind-blowing performances. And other interesting discussions focused on satisfying your appetite for the art. Meet the minds behind great creations and let them inspire you to greatness. Watch Art House on Saturday, 9:30 p.m. and it will be broadcast on Monday, 12:30 p.m. Art House, artifacts right at your doorstep.
And now to our interview segment. Against the background of the recent bomb blast and other nagging security issues in the country, my guest, Mr. Fola Othowori, former Solicitor General of Lagos State and also a former Director of Public Prosecutions (DPP) in the state, thinks that there is a need for clarity in the functions and responsibilities of the Nigerian police force. Having worked closely with the force even now as a fund manager, Mr. Othowori thinks that the institution, like many others in the country, is greatly in need of character. What exactly does that mean?
Let's start with asking the question of who is constitutionally responsible for law and order, for security in the country. A lot of people have misconceptions, but let's start with clearing those misconceptions. Who is constitutionally responsible?
Well, I would divide it into primary and then secondary responsibilities under the Constitution. Now, constitutionally, the police, the Nigeria Police, under the leadership of the Inspector General, and that office is the only law and order and security office created by the Constitution. So primary responsibility lies with them. And from independence, the police have remained the primary responders to law and order issues, security issues, therefore with police stations in virtually every part of Nigeria. Under the Police Act, when we talk about political responsibility, Section 9 specifically states that operational command of the Nigeria Police will vest in the president. So the president has a statutory operational command of the Nigeria Police, which he can exercise directly or through delegation. Now, secondary, I mentioned secondary. Now, the secondary responsibility lies with the governors under the Constitution, but it's a very limited mandate, lacking in operational command, deployment, funding, etc. What the Constitution says effectively is that the governor may give such lawful orders as the situation requires to the Commissioner of Police in his state. And let's be clear that it is not really Commissioner of Police of the state, but in the state, deployed from the federal, from Abuja, to take command of police location, police headquarters in the state. So it's an extension of that central power. But that power he has to give orders is limited by a proviso, which gives the Commissioner of Police in question the right to defer responding to those orders and to get clearance from the minister or whichever authority in Abuja. So you can see that it's a very limited mandate. Now, the other issues of security are budget, that is legislation and budget. And police is on the exclusive legislative list, which means that in terms of budgeting, funding, and so on, and even laws, as in amending the Police Act or creating a totally new Police Act, is exclusively limited to the National Assembly. So that is the structure. Then, of course, you have other components of the security and law enforcement network, which is the State Security Services, again, federal, again, accountable to the president. The NIA, which is the offshore arm of intelligence, again, central. And then you have all, yes. So the states have no powers whatsoever to create agencies with what you call monopoly of force capability, which is one of the key components of ensuring law and order and security, especially in a state as complex, fractious, and rather challenging as Nigeria is.
Now, you've been involved with security issues. You've worked with the police force.
As a prosecutor, yes, and now as a fund manager, yes.
Fund manager, criminal prosecutions, and all of that. So you understand all of the complexities
some of them.
Of the country and all of that.
Some of them.
What kind of police force does Nigerians deserve?
We need an elite police force, elite, one that is respected, is quality, and is not subjected to the kind of indignities. Elite. I'll explain.
Okay.
It's the kind of indignities that sometimes men of the lower ranks are subjected to, sometimes even treated no better than domestics. I think when I say elite, we're talking about, elite does not mean wealthy or high up. What it means is capable.
Okay.
You know, when we say elite, we say that in the business of law enforcement, you need a capable police force that can hold its own, whose members have the confidence to perform their duties, are not overawed by power, and who get full institutional support from the high command and all the other agencies that are charged with ensuring that they are able to function. So elite means capable in all the specialist fields of policing, who are properly kitted, catered for, and protected from the vagaries of our political system, which tends to many times see them as mere VIP protection rather than, law enforcement officers. So we've tended to build a low-income police force, and then we blame them for being unable to live up to certain expectations.
Yes, let's pursue that further. To go into specifics, what kind of tools, what kind of approach, would be deployed in ensuring this elitist police force?
Not elitist.
Elite police
elitist
force.
Is not a positive. Elite, capable. Well, first of all, you have to look at a number of issues. First of all, the filter through which a citizen has to pass before becoming a police officer, not a policeman, but a police officer, is critical.
Okay.
What quality of man do you want? He must look the part. He must bring confidence wherever he goes. He must have the intellectual capacity, not PhD capacity, but intellectual. He must be knowledgeable to a degree of how the world works. He must be properly trained. The standards in the police colleges today, I mean, no real deliberate, genuine investment has gone into their improvement in the last 30 years. And I say this with knowledge. Then we must define his mission. What is his mission? In the 60s, there were no other parallel agencies for law enforcement. It was the police. So everything was concentrated on the police. They dealt with traffic, they dealt with public order, environmental issues, investigation, riot, all the issues that make up the structure or architecture of crime, security, law enforcement. And they were described in the 60s, just before the war, by all observers, foreign and domestic, as being excellent. Another issue we should look at is the administration and management issues, which for me have not been given enough attention.
What do you mean by administration?
Because it's an organic whole, which is made up of many parts. They have to be resourced. They have to have enough men skilled in various needs. You have to have offensive and defensive drivers. You have to have hostage negotiators. You have to have all the component skills that make for an elite force. If we call Special Weapons and Tactics Squad, say of Kansas, elite, it is because when it is called upon in certain situations, it does it better than anybody. That's what you mean by elite. Capable, above the norm.
With the necessary skills.
Necessary skills and necessary support. Now, when you look at the police today, and this is not an overnight thing, the military came and sort of downgraded them, then we created all kinds of parallel agencies, the Civil Defense Corps, ICPC, EFCC, and all of these, FRSC. Now the question must be asked whether things have improved with the creation of these agencies. I guess the jury is still out on that. But I believe that the police have suffered by this amputation of functions. Now, if you have created these agencies, it is still the police that deals with the key threats to communal and state. Terrorism, armed robbery, fraud, murder, assault, public order, they are still police functions. So, if we clearly want to make up our minds, we have to define the mission rubric within which the police. So we say, okay, traffic is no longer your responsibility, so we save a little effort there that's going nowhere. What do you call it? Public order, environmental offenses, and so on, and concentrate their skills on these key challenges too. For me, there doesn't seem to be any clarity of function. And until you have clarity of function, you can't properly direct your resources. So that intelligence is a standard and vital police function.
And all of this, the buck stops at the central.
Definitely. Because they are the only ones that can make the changes by the law, by policy, by administrative changes. They are the only one. Nobody else can interfere with the internal mechanisms of the police than those charged with the power constitutionally.
Is that the kind of police force that we have today is a reflection of the government at the center? Of
the past 30 years, of the kinds of governments we have had. Definitely.
So you say that the way to go is a review of the
we need to review the structure. We need to determine, as I've said, who is responsible. The whole concept of governors being referred to as chief security officers is a diffusion of responsibility, a convenient escape route for those who are directly responsible for, So, because Chief Security Officer is not in the Constitution, it is not created by any statute, it has no functions determined, it's from the perspective of expediency. Yes, governors have had to step in to fill vacuums, but they are not the primary responsibility, they don't hold primary constitutional responsibility. We decided to have a constitutional government so that we are clear who have the mandates among the various tiers of government. And what you find today is that the federal government is operating in areas where it doesn't even have a funded mandate. So I say that if it concentrated on the key areas where it has a constitutional mandate, we might get more of the desired outcomes that we all wish for and hope for and know that we are capable of. I despise the whole idea. I despise it. The idea that certain individuals, because they have influence or money, can use officers of the Nigeria police as private guards. The Police Act in no way contemplates any of that. And then it's done in an offensive and aggressive way. So these are it is the character of the country that needs to change. The character of its leadership, the character of its institutions. That's where I think the fundamental problem lies.
But on the whole, it appears to me like it's a matter for constitutional reform.
Not necessarily. You see, constitutional reform will not always...
Because you said that it's on the exclusive list.
Yes.
The federal is started with all of this
yes.
And if we've had all of these failures, then constitutional amendments...
It is not purely because of the multiple items on the list that Nigeria functions in this rather lurching manner. No. There are fundamental incompetencies and inefficiencies in the system. And that's basically because we've lost a lot of institutional knowledge. And therefore, many people do not know who is responsible for what. You said it at the beginning. You said we need to clarify the issue of responsibility and accountability because there's a lot of uncertainty about that. So, amending the Constitution, per se, without changing the character of the institution is not. Now, INEC had a relatively successful outcome because the chairman changed the character of the institution by changing certain rules. You didn't need, yes, the Constitution was amended and the Electoral Act was amended, but it could still have failed if you didn't have the kind of leadership that you had. So the key thing is we don't always think that let's wait till the next constitutional amendment before we have improvement. I do not subscribe to that. I mean, if the country is determined, if its leadership is determined that it will improve policing, it will do so.
And that's the program this week. If you have questions or comments, please get in touch via email, Facebook, or Twitter. The addresses are on the screen. I'm Shola Adeku, and I thank you for watching.